And of course, there's the Padilla case, really, I think, frightening claim that the president has the power to designate an American citizen picked up on American soil an enemy combatant and hold that citizen without due process for the duration of the war on terror. That is about the most frightening power you can imagine an executive having. I hesitate to tell this story, but it's a true story, and I think it's, while lurid, it's illustrative. And some of you are probably familiar with this. After he left the Office of Legal Counsel in 2003, John Yoo continued his practice of being, an unabashed defender of executive prerogative. And he had a debate with a professor from Notre Dame Law School, and they had an interesting and cringe-inducing colloquy where this is December 2005 in Chicago, and Notre Dame law professor Douglas Cassell asks John Yoo, the author of the torture memos, if the president deems he's got to torture somebody, including by crushing the testicles of the person's child, there is no law that can stop him? Yoo replies, no treaty. And Cassell follows up, also no law by Congress. That is what you wrote in the August 2002 memo. And this is Yoo's answer. I think it depends on why the president thinks that he needs to do that. So yeah, people are interested in executive power again and the possible limits to executive power. Going back to the framing, David covered it so well. I'll just make a few quick points to supplement what he said. The theory that John Yoo has advanced, that the administration has embraced, often gets lumped in as unitary executive theory. And while that's true, the original unitary executive theorists had a narrow, this is unitary executive theory on steroids. It is not simply that there's one executive and that he has the right to remove officers without approval of Congress and that he controls his subordinates within the executive branch. The theory advanced by Yoo and embraced by the conservative movement goes well beyond that. And it rests, as general unitary executive theory does, on the vesting clause of Article 2, the first sentence of Article 2 of the Constitution, which, unlike the first sentence of Article 1, listing Congress's powers, appears to grant the executive power as a whole, not limited to specific enumeration. Now, there's a whole debate about that, and there are arguments on each side. But John Yoo's interpretation of the power granted in the vesting clause in Article 2 is that the framers understood the executive power in terms in the terms of the British model, that these were really the powers of a king. He uses in John Yoo's book, The Powers of War and Peace, he takes a quotation from the anti-federalist Cato, who charged that the proposed Constitution contemplated royal powers for the president. And Yoo writes in The Powers of War and Peace that, quote, Cato correctly concluded in the realm of practical politics, the president's authority under the Constitution did not differ in important measure from that of the king. That's a pretty broad and surprising statement. And given that I work at the Cato Institute, I don't usually get to say things like this, but Cato was wrong. We're not named after that Cato. The framers did not, as David points out, embrace the British model. In fact, the man who introduced the motion for to have the executive be one person at the convention, James Wilson, as he introduced the motion, made clear that he, quote, did not consider the prerogatives of the British monarch as a proper guide in defining the executive powers. Some of those prerogatives were of legislative nature, among others that of war and peace. The only powers he conceived strictly executive were those of executing the laws and appointing officers not appertaining to and appointed by the legislature. So this is this claim that the framers embraced the British model as the source of the chief executive that they designed is denied by the very person who introduced the motion to make the executive one person. He's, of course, wrong on, and that comment was echoed by a number of other participants in the convention. Briefly on enemy combatants, the claims made in the Jose Padilla case and the claims made on by some so-called originalists that you know, the president has the wartime power to essentially make people disappear, take them out of the civilian process. There's a terrific article by a professor at Vanderbilt's law school named Ingrid Wirth. The article appears in the summer 2004 edition of the Northwestern University Law Review, and it's called Lessons from Mr. Madison's Forgotten War. It's about the War of 1812 and some of the litigation that went on in the state level when various military officers would confine American citizens suspected of aiding the enemy. And she points out that during the War of 1812, courts issued writs of habeas corpus to and awarded damages against military commanders who did this. Madison, when this happened, conceded and respected the decision, and you know, the people who were confined were released. And Professor Wirth also points out that the courts during this time, including some important jurists like Chancellor Kent, the courts held military personnel personally liable for assault, battery, and false imprisonment if they detained U.S. citizens not triable by court-martial. Now, you talk about you know, we keep hearing this existential threat to America, and we keep hearing how things are different. I mean, this is a war in which the White House was burned to the ground, and in the midst of it, you have courts rejecting this idea that simply because the country is in danger, that the president has the power to use the military to permanently confine U.S. citizens without trial. So I think that's an important point and maybe not widely recognized enough.